Thank you for having me here. It's great to be back in Chicago. I'm the CEO of Fastcase. I teach at Georgetown Law Center and Cornell Tech. I teach a class called The Law of Robots, how law changes in the presence of decision-making machines. I also am an editor of RAIL, the Journal of Robotics, Artificial Intelligence, and Law. And I've just finished editing a book that's coming out in the fall called Data-Driven Law. I see Bill Henderson here in the front, who has a chapter in the book. And that is about how lawyers and the legal profession can use data to deliver more sophisticated and new legal services. My company, Fastcase, provides legal research software. I think many of you know it's a free member benefit for members of the Illinois State Bar Association and 29 other state bar associations. We recently also acquired a company called Docket Alarm that does docket analytics and informs data-driven decision-making by law firms. And we've been working on a tool called the AI Sandbox that helps lawyers to use AI tools like IBM Watson, Contract Suite from LexPredict, and many others to understand their own data and their clients' data better. So I have on the brain today kind of artificial intelligence and data and how we can use those things to make legal services better. So clients bring these problems to us as lawyers. Corporations have bet the company litigation, questions they need answered. Family law clients come to us with the most stressful events of their lives, and they ask us legal questions, and we answer these questions with guesses. We do the best we can, we use our experience, but we guess. Now, I know many lawyers in the room, myself included, would say those aren't guesses, right? Those are opinions and reasoned judgment based on years of experience. Data scientists have a term for this kind of judgment. They call it hunches. The truth is we have very limited data in which to draw opinions. And I am going to talk today about ways that those kinds of hunches, maybe in the presence of data, can be actually malpractice. Artificial intelligence is a baby. It's adorable. It's so cute. It's also growing according to Moore's law, which says that the number of transistors on a chip doubles every 18 months to 2 years, and its price gets cut by half, which means this baby will double in size every year. So today we're going to talk about data and artificial intelligence in the full life cycle, from its baby stage all the way to adulthood, and what the ethical implications are of each stage of that development. And because I like metaphors, I'm going to think about this as a lawyer. So in Nikki Black's talk, she said, will artificial intelligence replace lawyers? No. But what it will probably do is replace legal work, and hopefully the worst legal work. And so we're going to talk about what work AI replaces all the way through the life cycle. So let's start with a briefcase. We're going to use artificial intelligence as a tool, like you would use a briefcase, in the practice of law. What ethical implications are there to using data and artificial intelligence in the practice of law? And conversely, what ethical implications are there to not using data and not using artificial intelligence as a tool for the practice of law? So you guys in this room are probably familiar with the model rules of professional responsibility, Rule 1.1, the duty of competence. And for the ethics nerds in the room, comment 8, saying that the duty of competence includes a duty of technological competence. I have a cardinal rule of talking: don't put a bunch of words on a slide, but I'm going to do it in this case to illustrate a point. Rule 1.1 says a lawyer shall provide competent representation to a client. What does that mean? Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. All of the lawyers in the room immediately say, the crux of this is, what is reasonably necessary? Is it reasonably necessary to use the most advanced technology? Is it reasonably necessary to use the data? Similarly, Rule 1.3 of the model rule says a lawyer shall act with reasonable diligence and promptness in representing a client. Okay, would it be malpractice in the age of Blackstone to not cite a case that wasn't in Blackstone? Probably not. You're using the tools of the trade. Would it be malpractice to cite a case that had been overturned, but that wasn't marked overturned in Shepard's citator? No, you are using the most advanced tool of the trade. Now, in a world with data analytics, a world we're not in 2018 for the most part, but will be in 2019 and 2020, will it be malpractice to take to trial a case in the presence of a settlement offer? If you can know from the data that the settlement offer is 40% higher than settlement offers that were accepted in similar cases, if you know your settlement offer is 40% higher than the mean or the median of settlements in similar cases, is it malpractice to bring that case to trial? What if you could tell that the likelihood of winning your case based on analytics, based on similar cases in similar circumstances in the similar court, if you knew the likelihood of winning your case was 20%, if data and analytics can tell you the settlement offer is high based on the facts, and your chance of succeeding is low based on the facts, and you ignore those things and take the case to trial, does that constitute malpractice? Is it a violation of the duty of competence? What if those metrics exist and you don't even look? What if you just say, based on the 4 matters like this I have done in the past, I think the settlement offer is too low and I'm an awesome lawyer. So we are going to win at trial and I'm taking this case to trial. Could that be a breach of your duty of competence or your duty of diligence to ignore the presence of that data? Look, these facts aren't unknowable. They are simply unknown. Is it a mystery who wins and loses cases? No, it is not. In fact, there are very good legal research services that publish all the opinions of these cases. It's just hard to find the facts from those cases today. It won't be hard in the future, right? We'll have the ability to tell where cases settle and what your chances of winning in the future are. Lest you think I'm trying to sell Docket Alarm from Fastcase, there's also Lex Machina and a lot of other services that provide these kinds of analytics. There will be many of them in the future. So that's AI and data as a tool for lawyers and the ethical implications of that. What happens when AI can do the work of an associate? Let's call it the worst work that we do. Lest you think I'm talking about our flying car future, we have this software today. It exists among us. It is called electronic discovery. Back in my day, lawyers used to read through warehouses full of boxes looking for paper that we knew didn't exist. We nevertheless had to read all the paper to make sure it didn't exist. I'm here to tell you it was terrible. Today we have software that does that, right? Electronic discovery software uses artificial intelligence, and it's great. AI already knows where Waldo is. It's great for brute force tasks. Is it perfect? No. Let me introduce one of the greatest challenges in artificial intelligence today. It's called Muffin or Chihuahua. There are teams of engineers at Google trying to figure this one out. So, as a lawyer using artificial intelligence to provide some of this work, we also have ethical obligations. Rule 5.3, the duty to supervise, basically says that lawyers who are using these tools, who are working with non-lawyer professionals, who are working with other lawyers in the firm, shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional obligations of a lawyer. 5.3b basically says the same thing, that people's conduct is similarly compatible with the ethical responsibilities. I'm not going to tell you that AI is robot lawyers. Anybody who tells you that, run. No such thing as robot lawyers, but I am going to tell you that as lawyers, we have professional responsibilities to make sure that the people and the tools who work for us comport with those responsibilities. This is a big deal here because of algorithmic bias. Artificial intelligence uses algorithms which software geeks like me sometimes say is completely neutral. I'm here to tell you there's no such thing. Software has biases. And those biases can affect the quality of your representation, and they'll have ethical implications as well. What happens when artificial intelligence does higher order work? When it can start making recommendations to the firm, deciding about things like whether to take a case to trial, how much to settle a case for. In the case of brief services, when it writes the first draft of the brief, there will be cases where artificial intelligence recommendations differ from the recommendations of lawyers. And I'll tell you, this will have big ethical obligations and responsibilities. It will also have big insurance implications. When the software says, don't take this case to trial, and the software on balance is right more often than not, and lawyers nevertheless take the case to trial, they may face different sets of ethical obligations. And by the way, where the lawyers think the case should not go to trial and follow the advice of software and nevertheless take it to trial, as one example. You can also have malpractice obligations there as well, where lawyer professionals and software disagree about practicing law, especially where the software typically is right, will have different obligations. Managing partner seems a little far-fetched, the idea that we could work for a machine, but let me just posit, we have such systems right now. One of them is called Uber, software that tells armies of people where to drive, to pick up strangers in their car and drive them someplace else along a route that is predetermined. There are thousands of people who work for machines right now. There's no reason to think that law is going to be any different. We will have software that tells us how to deliver legal services. And by the way, when that's true, there will be a lot of services that are delivered direct to consumers, which raises the question, when does software become the unauthorized practice of law? Luckily, we have hard and fast rules about what constitutes the unauthorized practice of law. I love that that's a punchline. Nobody knows what constitutes the unauthorized practice of law. It's different in every state. It is sometimes case law, sometimes it's regulatory. A regulator recently told me that if a computer can do it, it is not the practice of law. So I am telling you that that is on a collision course with Moore's law. It can't be quite that simple. All right, so I think I'd like to say in conclusion, as lawyers, and I say this as a lawyer myself, we tend to have a status quo bias. We believe that doing nothing is always ethical, and anything we do different is risky and has large ethical implications that we need to seriously consider. It keeps us planted right where we are. In a world that changes and changes fast, doing nothing could be the most ethically risky thing that we do. As the availability to answer these questions goes forward, we will have obligations as well to advance the state of the art of the practice of law. If the tools are there, ignoring those tools, not using those tools, invoking our status quo bias, could be an ethical breach just as much as anything else. Do you have to be a computer science PhD to practice law? No. I would suggest that you follow the rule of Keanu. When it comes to legal tech, you don't have to be Neo, but you can't be Ted. Thank you very much.